Namaskar to all the viewers across the country. I am Sanjula Haldar, Deputy Director in the Directorate of Income Tax PRPNP at Mayur Bhavan, New Delhi. Welcome to another session from Samvad. As part of Samvad series, today we bring to you discussion on the topic Harmonization of Provisions Pertaining to Charitable Institutions and Trusts. For the discussion, we have with us today Shri Anurag Sahai, Principal Commissioner of Income Tax, Bengaluru. Shri Anurag Sahai belongs to the 1991 batch of the Indian Revenue Service and is presently working as Principal Commissioner of Income Tax Verification Unit, Bengaluru. Sir is an alumnus of Jawaharlal Nehru University, New Delhi and National Law School of India University, Bengaluru. Sir has also pursued public policy at the University of Washington, USA. Sir has worked within the department in Kolkata, Chennai, Mumbai and Bengaluru in various capacities, including specialized verticals of international taxation, exemptions and on deputation. Thank you, sir, for accepting our invitation for this episode of Samvad on the topic Harmonization of Provisions Pertaining to Charitable Institutions and Trusts. Sir, you spoke about deduction under Section 80G of the Act. So could you please tell us that what all exemptions are available under Section 80G to the donors and the trusts and what all compliances have to be made by 80G approved entities?
See, there are several questions regarding 80G deduction which you've asked. Let us understand them in the right order sequentially. First and foremost, an entity has to be approved under Section 80G of the Act. Approval under Section 80G is on the identical procedure and identical form as approval under Section 1023C or registration under Section 80G of the Act. Now, under Section 80G, there are two kinds of entities. The first kind of entities are notified by the CBDT under Section 80G2 of the Act. Now, the notified entities under Section 80G2 are institutions of national eminence and funds like Prime Minister National Relief Fund, etc. Now, these notified entities, any donations made to them, the donor can avail 100% of deduction of the amount donated, subject to the condition that it does not exceed 10% of the gross total income of the donor. Also, it has to be noted that entities notified under Section 80G2 need not apply or avail approval under Section 80G of the Act. The approval required under Section 80G of the Act is governed by the provisions of Section 80G5 of the Act. Under Section 80G5, any charitable entity desirous of availing donations, they have to apply. If they are applying for first time, they have to apply in Form 10A and avail provisional approval, and thereafter commencement of activities, avail regular approval. Once the approval is in place, these entities can solicit and accept donations from public, and on this amount of donation made by the donor, a deduction under Section 80G is available to the extent of 50% of the amount donated, subject to the condition that it does not exceed 10% of the gross total income of the donor. Apart from these, there are two compliances which are to be made by entities registered under Section 80G5 of the Act. Number one, they have to file an annual statement of donation in Form 10BD. Now, this annual statement of donation form is to be filed by 31st May every year, and it contains the details of all the donations received by that entity, the PAN number of the donor and the relevant amount. The correction statement also of Form 10BD can be filed, and in that sense the annual statement of donation is very much akin to the quarterly TDS statement filed by a tax deductor. The second compliance which has to be made by the entities registered under section 80G5 is to issue a certificate of donation to the donor in form 10BE. Now this certificate issued in form 10BE enables the donor to avail deduction of 50% of the amount donated as per the specified rate, subject to it not exceeding 10% of the total income, gross total income of the donor. So this is in nutshell the basic provisions governing the deductions under section 80G of the Act.
Sir, could you please tell us what has been the major thrust of changes brought by the Finance Act 2022?
See, the explanatory memorandum to Finance Act 2022 details the roadmap of the changes brought about in the arena of charitable institutions. The major thrust of the change has been the harmonization of provisions relating to first regime and the second regime. The other two critical areas which has been dealt in Finance Act 2022 has been effective implementation of the exemptions regime and also bringing clarity of taxation in certain exceptional circumstances. In the Finance Act 2022, several new concepts such as specified violations and specified income, etc., has been introduced, all with the singular intention of bringing clarity and tax certainty.
Sir, could you please explain to our viewers what do you mean by harmonization of provisions of the two regimes?
Certainly, but before I do that, a bit of background may help the viewers understand the process of harmonization which was undertaken in such painstaking detail by the Finance Act 2022. You see, the first regime under section 1023C and the second regime under section 12AB both essentially undertake the same purpose, that is to accord exemptions to the income for a public, charitable or a religious purpose. Now over the years, with several legislations happening and amendments happening, a lot of significant variations in operation of these two regimes occurred. Let me give you some specific instances so that you can understand this better. The accumulation report, which is Form 10, was only notified for second regime, not in the first regime. Similarly, the fact that any accumulation carried forward beyond 5 years would be taxable was only available under the Act in the second regime, not in the first regime. The process of registration of both these regimes were different, and similarly there were several granular differences which was creating confusion in the minds of the taxpayers. So in order to bring clarity in the law and also harmonize both these regimes, a great deal of effort was undertaken through Finance Act 2022, and now almost complete harmonization has taken place, in the sense that there is substantial consistency between both the regimes in all the major areas. Take for instance the process of registration. It is identical now. Form 10 is for both the regimes. Audit report is notified recently and common to both the regimes. The process of cancellation of registration and the concept of specified violation or the specified income all have been brought at par, and now there is a clarity in terms of the way provisions are structured, and that is why it was mentioned in the explanatory memorandum to Finance Act 2022 that harmonization of two exemptions regime is the thrust area of these amendments.
Sir, going further, please explain to all our viewers what is meant by specified income and under what circumstances is specified income taxable.
Certainly, I would be glad to explain that. You see, prior to introduction of the concept of specified income, even a minor infraction of law could potentially result in complete denial of exemptions. Now, this was bringing a lot of hardships to the taxpayers. So, in order to give clarity on various contentious areas which were resulting in litigation reaching to the highest court of the land, through amendment in Finance Act 2022, the concept of specified income and a new section 115 BBI was introduced. Basically, 115 BBI lists out 5 instances of infractions which will entail these incomes to be specified income and taxed at the rate of 30%. Now, these specified income would be when accumulation has been denied. There may be an instance where Form 10 has not been filed or Form 10 is belated, so proper compliance is not made, or where accumulation has been carried on beyond 5 years, or if investments have been made in non-permitted mode, as I mentioned earlier with regard to discussion on section 11.5, or accumulation has been made beyond Indian shores in the second regime, and lastly, if a benefit is passed on to a specified person. Now, specified person is defined under section 13(3) of the Income Tax Act, and specified person is a person who is a trustee or a director or a relative of a trustee or a director. So, that definition is there. Anyone who is interested closely in the affairs of that approved charitable entity. Now, if any benefit is passed on to that person, it is not permissible. So, that particular amount is also considered under the umbrella of specified income. So, now it is very clear to the income tax authority that when administering or assessing the affairs of a charitable entity, if these infractions are occurring which are mentioned in section 115 BBI, it automatically becomes specified income taxable at the rate of 30%, and it does not become a case that the entire exemptions available to the taxpayer is denied.
Sir, another new concept introduced by the Finance Act 2022 and also mentioned by you is specified violations. So, what is the significance of this concept?
Specified violation is a very significant new concept introduced by Finance Act 2022, as you rightly say. You see, registration or approval granted either under the first regime or the second regime or under section 80G of the Act is subject to cancellation if the commissioner or the principal commissioner notices occurrence of specified violations. Now, this specified violation has been defined and detailed in the provisions of section 12 AB of the Act and also 15th proviso to section 1023C of the Act. Let us understand what are the specified violations. Now, there are 4 specified violations which are common to both the regimes. First, if the trust or the institution applies its funds for anything else other than the objects of the trust. Number 2, if the trust or institution is carrying on an incidental business and that business is not held to be incidental, or if the trust or institution is not maintaining separate books of accounts for the incidental business. Third, if the activities of the trust or institution is not genuine or are not in conformity to the various conditions for which it was registered. And fourth, if the compliance of any other law material to the grant of registration is not made. In such instances, specified violation occurs. There are two separate specified violations which is applicable only to the second regime. That is, if an activity is undertaken for a private religious purpose or if an activity is undertaken for the benefit of a particular community or sect. So, these are also specified violations. Finance Bill 2023 has recently introduced another specified violation, and that is if a provisional registration is granted on the basis of an incorrect or incomplete application. As I have mentioned earlier, grant of provisional registration or approval is an automated concept. So, when later it is seen that the grant of registration is based on a incorrect documentation or incomplete application, in such cases also specified violation would occur. Now, how would an income tax authority notice specified violation and who is the prescribed authority? So, here the Commissioner of Income Tax or the Principal Commissioner of Income Tax is the specified authority. He may notice specified violation either suo motu or on reference from the assessing officer, or if that case is marked after necessary data analysis in terms of the risk management strategies specified by the CBDT. In all such scenarios, the Commissioner or the Principal Commissioner will issue show cause notice to the taxpayer and give sufficient opportunity to the taxpayer to make necessary compliances, and after that the Commissioner or the Principal Commissioner will have to pass an order either cancelling registration or an order refusing to cancel the registration for the reasons mentioned in the order, and such an order has to be passed within 6 months of the end of the quarter in which the first show cause notice on specified violation was noticed by the CIT. So, this in short is the concept of specified violation, and the details, if the viewers would like to refer to, they are available in the provisions of section 12AB4 of the Income Tax Act for the second regime and 15th proviso to section 1023C of the Act in the first regime.
So, the Finance Bill 2023 has recently been introduced by the Honorable Finance Minister. So, what are the changes that are proposed in the Finance Bill 2023 which relate to the provisions for charitable institutions?
See, the Finance Bill 2023 continues the process of rationalization and simplification of tax laws relating to charitable entities. The journey which has started with Finance Act 2020 with the new scheme of registration, it is in the same continuum that Finance Act 2023 has also brought in certain significant changes. We also see that there is a very conscious attempt of repealing redundant laws and making our tax laws simpler and cleaner. Some of the major highlights of the changes proposed with regard to charitable institutions in the Finance Bill 2023 that I would like to bring to the notice of the viewers are as under. Firstly, an anti-abuse provision has been introduced. Viewers will recall that I have mentioned that charitable entities have to apply 85% of their income towards the specified purpose as mentioned in their objects or MOA. Now, this application either can be directly by the entity, or it could also grant donations or contributions to a similar charitable entity engaged in the allied activity. The Finance Bill Explanatory Memorandum mentions that instances have come to notice that there are many charitable organizations who are just layering up various trusts and charitable entities and passing on donations from one to another, thereby retaining 15% at each layer, with the result that the original intention of the law, that 85% of the income earned by the property held under the trust and voluntary contributions has to be spent towards charitable activities, is getting defeated. So, in order to contain this, an amendment has been proposed in the Finance Bill 2023 that henceforth, when a charitable entity makes a voluntary contribution to another charitable entity, application will be reckoned only to the extent of 85% of that contribution and not 100% as was the case earlier. So, this is the first significant change with regard to the charitable institutions in the Finance Bill of 2023. Secondly, the Finance Bill of 2023 proposes rationalization changes with regard to use of corpus or loan or borrowings. You see, an entity can use its corpus, funds or loans and borrowing for its specified purpose. Finance Act 2021 brought in an amendment that the amount will be treated as application only when that corpus or the loan borrowing is repaid and not at the time of its first application. Now, in continuation with the same provision, a rationalization change has been proposed in Finance Bill of 2023 that any amount which is repaid by way of loan or put back into the corpus prior to any application made before 1/4/2021 will not be permissible. This has been done for the precise reason that prior to Finance Act 2021, such an amount would have been directly claimed as application by the charitable entity, and if it is allowed again now, when it is being put back into corpus or the loan is being repaid, then it would amount to double deduction. Hence, any allowance with regard to repayment of loan or putting back the amount used from corpus will be allowable only if the same has happened post 1/4/2021. So, this is the second major change with regard to charitable institutions in the Finance Bill of 2023. Thirdly, in continuation with the same corpus and loan and borrowing provisions, it has been proposed in the Finance Bill that any putting back of amount into the corpus or repayment of loan would be allowed as application only if it is made within a period of 5 years from the date of application of that amount, either from the corpus or the loan or borrowing. Fourthly, as I have mentioned earlier also briefly, the due date for filing of accumulation report in Form 10 or Form 9A has been advanced. Earlier it was the due date of filing of return of income. Now in the Finance Bill it is proposed that these forms have to be filed 2 months prior to the due date under section 139(1) of the Act. The next change I would like to highlight in the Finance Bill is that as per the Finance Act 2022, the scheme of updated return of income was introduced, where a taxpayer could update its return of income within 2 years. Now, this resulted in an unintended consequence of charitable entities availing exemptions despite filing returns beyond the due date under section 139(1) or 139(4) of the Act. The Finance Bill proposes the change that exemptions would be available only if the return of income in ITR 7 is filed by the entities approved in the first or the second regime within section 139(1) or section 139(4) of the Act. Lastly, I would like to highlight that the Finance Bill 2023 proposes a new scenario for what is popularly known as the exit tax. Now, this exit tax is mentioned in the provisions of section 115 TD of the Income Tax Act, which taxes the accreted income of the taxpayer when an entity is converted into from a charitable mode to a non-charitable mode. Say an entity's registration is cancelled, then it gets converted to a non-charitable mode. So here the Finance Bill of 2023 has proposed that if an entity has failed to apply for registration under the new scheme and it was earlier registered under section 12A or section 12AA or section 1023C of the Act, then it would amount to mischief of section 115 TD and accreted income would be taxable. The second scenario which is also mentioned is that if an entity which is registered under new scheme, either provisionally registered or regular registration, if it fails to reapply, in case of regular registration it fails to reapply after 5 years, or in case of provisional registration it fails to reapply after 3 years, then that would also amount to coming under the mischief of section 115 TD of the Act. The basic philosophy behind this is that all through the life cycle of a charitable entity, its income is being exempt and it has accumulated assets which has been tax exempt. Now, when it is converting to a non-charitable mode simply by failure to reapply for registration, then that amount becomes taxable within the meaning of section 115 TD of the Act. And here the concept of accreted income is its fair market value of its assets over the liabilities as on the specified date of conversion. The specific provisions, viewers may like to refer to the provisions of section 115 TD. So this additional scenario has been brought into Finance Bill 2023, and it is proposed that these will also amount to mischief of section 115 TD.
Thank you so much, sir, for patiently explaining all the provisions related to charitable institutions and trusts.
We hope this session gave you the necessary insights on what are the various do's and don'ts that charitable institutions have to adhere to for the continuance of exemptions under the Income Tax Act 1961 and what happens if a charitable institution receives voluntary contribution in a non-specified mode. Please join us for the next session of Samvad to know more about what are the significant changes proposed in the Finance Bill 2023 in relation to the provisions relating to charitable institutions. With this, we come to the end of today's session on harmonization of provisions related to charitable institutions and trusts. I thank you all for joining us for this episode. Do follow us on our social media handles on Facebook, Instagram, LinkedIn, YouTube, and Twitter, and keep watching for updates on more educational and informative content. Until the next time from Samvad, thank you and Jai Hind.